Yeah, this is Paul. Yeah. I was reading section 4 of Article 4. Yes. Article 4, the states. I had found the word guarantee. Okay. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Now, in reading the response from the state about why it is that they had the right to prosecute me, why they had the right to jail me, I'm just going through their response, and it seems to me that Mrs. Budnek didn't actually petition the court. So the state committed the crime of domestic violence against the United States. Defense counsel requests that the state prove the defendant received actual notice of the petitioner's request for a permanent order and that the Clallam County Superior Court had sufficient basis to justify the imposition of the permanent order. Now, somebody in Clallam County Superior Court believed that they had sufficient basis to justify the imposition of the permanent order, even though they had not fulfilled the necessary requirements of the Violence Against Women's Act. There was no actual notice or opportunity to be heard. Uh, Received actual approved permanent sufficient basis to justify the imposition of the permanent order. um, if the petitioner had wanted a protection order, you would have thought that she would have signed it. Now, when a state commits the crime of domestic violence against the United States of America, and I email those in law enforcement and I give them copies of RI.PDF, and then I include what the state court instructions require: proper and timely notice. And then I include what the federal legislation requires. And then I include what the Constitution of the respective states require. And then I include what the United States Constitution guarantees. It looks to me like somebody in the United States decided to commit the crime of domestic violence. Violence against the rights of myself and my family. Domestic violence against the laws of the United States. Domestic violence against the Republican form of government. And domestic violence against the constitutional rights of Americans. Now, when I read this, as noted above, these are not required elements of the charged crime. The state does not have to prove that they committed domestic violence because they did commit domestic violence against the Constitution of the United States. Clallam County committed the crime of domestic violence against the United States of America. Now, as I read this, the validity of the underlying no contact order is not an element of the crime of violating such order. The validity, whether or not the no contact order is valid, has nothing to do with whether or not I committed the crime of violating the no contact order. Now, to issue a no contact order that is not valid means that in the state's response that I can still be charged with the crime of violating it. I would think that the validity of the no contact order, meaning was it valid, was it issued according to the laws of the state of Washington and the United States, because if it's not valid, then you can't get arrested for violating it. The validity of the contact order. Now, when you consider that I have emailed a number of screen prints that the petitioner did not request the protection of the protection order, but the state decided to commit the crime of domestic violence against the authority of the United States of America, and then they decided to arrest me when I was not in that city. They decided to. Now, I'm going to have to tell every judge and justice, okay, all of those in the ATF, the DEA, and the United States Marshal Service, that deciding not to enforce the laws of the United States means they're complicit in domestic violence against the Republican form of government of the United States. Aiding and abetting those that have committed treason.